This lesson focuses on ways to work with attorneys and how the process can work to the benefit of both you and the attorney. Problems can arise that are nobody's fault, but just reflect the system and the burdens of everybody's job responsibilities. Problems you may have with your own attorney differ from those you may have with opposing counsel. Depending on your attorney, he may not have as much time to work with you as you would prefer. This kind of problem does not surface right away. Initially, they want to bring you up to speed on the case so that you can independently perform your expert witness role. However, if you seem to be competent, your attorney may just leave you to your own devices. Consequently, you may find that your attorney will not spend much time helping to prepare you for the expert report writing process, or for your deposition, or even for your trial testimony. It can sometimes be frustrating to work with your retaining attorney in charge of the case. He may not fully understand the technical information when you explain it. While you explain things, especially if you are at the attorney's office, other co-workers or the telephone may interrupt you frequently. Sometimes the attorney simply does not listen to you or cannot concentrate on what you have to say. He may be focusing on the legalities of the case and may have only a limited appreciation for the subtleties in your profession. If an attorney calls to hire you the week before trial, it will be annoying. It will be very dismaying. You will not want to work with such an attorney. Sometimes they may call you 1 week before they have to declare that they have an expert witness. That can work sometimes if you don't have to start working on materials right away. They may have been working on the case, however, for the preceding 2 years. While you may take the case anyway, you will probably wonder why this attorney waited so long in the process to consider hiring an expert witness. You should certainly ask the attorney why he waited and use his response as part of your decision-making about whether you should take the case on. Whatever the time frame, you have to judge whether enough time remains for you to prepare properly. Sometimes you will discover after the attorney hires you that the opposing counsel's expert witness has already spent months reviewing evidence, making tests, coming to opinions, and even writing a report. Your attorney will hire you and ask you to do similar analyses, and always as soon as possible. Even worse, they will hope that you come to alternate opinions, and you will only have a limited number of weeks to do it. Think twice about taking on a case with any kinds of pressures like these. You may not have time to do what is needed to reach well-founded opinions. Attorneys have timelines, and sometimes limits on money to spend on expert witnesses. This can explain why you will sometimes have less time than you might like. Here's a tactic. Attorneys want your report and your testimony to be organized, clear, logical, and well presented. You will wish that they managed their own time that way. You will also sometimes wish that they simply did a better job of working with you. At times, as a result of this kind of thing, you should consider no longer working with them. This is especially true when cost consciousness on an attorney's part obstructs your investigation. Attorneys and their clients are sometimes sensitive to the costs of a case, and your explorations and investigations may entail additional expense. For example, you may believe that a site visit is essential. This differs from simply believing that site access is or might be useful. You might believe that you must make observations at a site of systems or people in operation. If you believe this, then you must tell your attorney and obtain advance approval for the activity and the expense. It would be unprofessional to express an opinion if you know that you still need a critical piece of information as part of the basis for that opinion. You would be remiss to do so, and your attorney would be unreasonable to expect you to do so. If your attorney prohibits you from doing a task that you believe is necessary, in that case, you should consider withdrawing. Another possible predicament that may arise: your attorney may try to influence your opinion by neglecting to provide you with some discovery information that he sees as negative for the client. I mentioned earlier that the attorney is not competent to tell you what evidence is positive or negative when it comes to your technical expertise. You have to insist that your attorney give you access to information that you think may be relevant. If your attorney refuses to do that, then you should also consider withdrawing. If you don't, an ethical and probably more qualified attorney will blindside you with that information during cross-examination. I spoke in earlier lessons about ethics and about ethical quandaries that can arise. Suppose an attorney hires you to work on a case, and neither you nor the attorney knows initially whether the client is guilty or not. You may discover during your investigations that it looks like the client is guilty. But what if one or two points exist in favor of your client? Perhaps you are asked to present them to reduce the costs of a verdict against the client. If the consequences for your client are severe, such as a $65 million verdict against them, the attorneys may decide to proceed to trial with the case anyway. The attorney may then ask you to simply do the best you can with whatever evidence is favorable and that might lead to significant dollar savings for the client. At this point, you will have to decide whether you want to put your reputation in the witness box, attempting to support a position in which you no longer believe. If you are now only trying to undercut the work of a plaintiff's expert with whom you agree, and you cannot in good conscience do this, you should tell your attorney and suggest that you withdraw from the case. But if you choose to do that, do not put your conclusion in writing, but do bring your billings up to date before you proceed any further. Beyond the ethical quandary, you have to realize that this client may not pay you a final bill, and this attorney may attempt to blame you for the eventual and even probable loss in the case.